Can the government restrict religious speech if it offends people of a different religion? Does the First Amendment's protection of religious freedom apply to state as well as federal laws? And how far does that protection extend? In 1940, the Supreme Court decided the case of Cantwell v. Connecticut. Jesse Cantwell, a Jehovah's Witness, was proselytizing and soliciting donations in a heavily Catholic neighborhood in New Haven, Connecticut. Cantwell asked two men on the street if they would listen to a phonograph record he had with him. The men, who were Catholics, agreed. Cantwell played the record, which contained insulting attacks on the Catholic Church. The men took offense and told Cantwell to leave unless he wanted to get hurt. Cantwell stopped playing the record and walked away. Cantwell was charged with violating a state law that required a license to solicit for religious and other charitable causes, and for inciting a common law breach of the peace. Connecticut prosecuted and convicted Cantwell of both offenses. The state argued that the convictions were a valid exercise of its power to prevent fraud and also to maintain public order. Cantwell argued that his conviction for inciting a breach of the peace violated his constitutional free speech and free exercise rights under the First Amendment. His appeal made it all the way to the Supreme Court. The court ruled unanimously for Cantwell. For the first time, the court held that the 14th Amendment's Due Process Clause incorporates the First Amendment's Free Exercise Clause, thus making the Free Exercise Clause applicable to state as well as federal government action. The court ruled that Cantwell's conviction was unconstitutional. The case demanded the weighing of two conflicting goals, the court said. Connecticut had an obvious interest in preserving civic peace, but the state must also respect constitutional rights. The state could act to prevent imminent threats to public order and the public safety of its citizens, including the members of different religious groups. But it couldn't unduly suppress speech, religious or otherwise, under the guise of conserving desirable conditions. The court explained that Cantwell had been in a public place. He had not interfered with traffic nor created a disturbance. He had not made physical threats or personally abusive remarks. His criticism of Catholicism was offensive, but he didn't call for violence against Catholics. Given all this, the Constitution did not allow his conviction for breach of the peace. Cantwell v. Connecticut is as relevant today as when it was decided. People continue to debate whether the government should regulate religiously motivated hate speech. Some argue that the state should forbid insults and harsh criticism of another religion, which reasonably can offend the religion's followers. Cantwell makes clear, though, that the Constitution protects such offensive speech in the absence of personal threats or an imminent danger to public safety and order. In the court's words, protecting speech, even offensive speech, is, quote, in the long view, essential to enlightened opinion and right conduct on the part of the citizens of a democracy. By applying the Free Exercise Clause to state laws, Cantwell advanced the cause of religious freedom. The case laid the groundwork for future decisions on civil liberties, and it remains a crucial precedent in the ongoing debate over how best to balance religious and expressive freedom with the state's interests in maintaining public order and safety.